Hello and welcome to another episode of Surviving Constitutional Law. I'm your host, Cameron Shamsabad, and this is a really exciting episode. We're on episode 3 now, so you've made it this far, you've begun your journey, and this week we're going to be continuing our discussion of state constitutions and state legislative power. This week we're going to be focusing on state constitutional amendment, but we're also going to be continuing our discussion of the nature of state power, and they really do go hand in hand. As I've said in previous podcast episodes, state constitutions don't really act in the same way as the Commonwealth Constitution does. State constitutions are considered to be ordinary legislation in most respects. So this week's episode really focuses on how the courts determined that state constitutions were not binding higher law in the sense that the Commonwealth Constitution is, and also what that says about the nature of state legislative power and the authority of state governments. From there we'll move on to discuss the manner and form provisions which the High Court has actually found are valid and binding upon state governments. These provisions are conditions which must be met and procedures which must be followed in order for a state constitution to be amended, almost like setting a special condition other than just ordinary amendment. So from a discussion of relevant case law and some of the historical precedents that we have in this area, I'm going to also contextualize this aspect of constitutional law in Australia by referring to the constitutional law of the United States and discussing how the interplay between state and federal governments actually occur over there as well, focusing of course on state constitutions and the way state constitutional law actually works in the United States as well, given that that is the example of federalism which our system was actually based upon. So today's episode is going to be really interesting and very broad, so I hope you'll sit back, relax, and let's dive into the topic together. So the constitutions of each Australian state is enacted by their respective legislatures. In this sense, they are, in a very real way, more analogous to other statutory laws that you would encounter, whether it be criminal law or various aspects of civil law, rather than taking on the status of a supreme law, which is afforded normally to entrenched constitutions, which would include, for example, the Commonwealth Constitution that we have on the federal level. By extension, therefore, as stated in our previous episode, the state constitutions are far more a procedural framework for the legislatures and the governments of each state to follow. The existence of the states is neither really created or vested in their constitution acts. Rather, their authority, in a way that's much more similar to the U.K., as I think I stated in my last episode, is really based upon a number of historical and legal precedents, as well as a recognition by the federal constitution, particularly in sections like 106 of the Commonwealth Constitution, which saves state constitutions after the move into the new federation period. To really exemplify this, Chief Justice Griffith actually wrote in the case of Cooper and Commissioner of Income Tax of the state of Queensland, the year 1907, and you can find that at volume 4 of the Commonwealth Law Reports, starting at page 1304, and the exact quote I'm going to give you is from page 1314. As to the origin of the plenary power of the states, Chief Justice Griffith actually wrote, and I quote him, "The power of the Queensland Legislature, like those of the Australian states, are derived from the grant contained in the Order in Council by which it was established. The powers of the Legislature still depended upon the Order in Council, and not upon its own restatement of those powers. If, for instance, they had purported to limit these powers, the original power would still have continued and might have been exercised." So what Chief Justice Griffith is saying there is that ultimately the Constitution of New South Wales doesn't actually, in Section 5, give plenary power to that state government. Rather, it is simply a recodification of what is already their inherent authority, coming from the Ordering Council which was given in the colonial history that I spoke about by the Queen and by the Parliament of the UK to the colonial legislature. So therefore, even if you were to limit the power in your state constitution, you would still have a situation where the underlying power would still be plenary, and the Ordering Council would still ultimately prove that, which is the source of state power. Some food for thought on this really is, if you take Chief Justice Griffith's opinion as correct, and obviously it's quite well stated in this case, it would mean that state legislatures are ultimately incapable of limiting their own power. They are really fixed in having plenary power. And the only way you'd be able to change this state of affairs and alter their ultimate authority is by either amending the Ordering Council by the monarch or by amending the Commonwealth Constitution to effectively bind the states to a lesser degree of power. Whether that's constitutional or not is also really questionable, but ultimately, given the state governments and their constitutions are subject, according to Section 109 of the Commonwealth Constitution, to that higher law, there is a possibility that that would be a process you can engage in to actually limit state constitutions. That's simply a bit of food for thinking in this episode, though, purely theoretical. But ultimately, it's very interesting to think that maybe these state governments are so empowered, they can't actually reform themselves to actually limit their power. Even if you were to put those limitations, ultimately they'll always have plenary power under the surface. So on this basis, state constitutions ordinarily can be amended and repealed by the same process as basically any other statute that you would find on the books. Our courts really did come to this understanding that states had ordinary statutory constitutions after considerable debate and controversy which arose from a series of cases in the beginning of the 20th century. It was not something which was automatically accepted. For some time after Federation, there were actually several prominent jurists, including Chief Justice Griffith, as I stated, who insisted that provisions such as Section 106 of the Commonwealth Constitution actually took state constitutions and gave them a higher status, or a new status, above that of ordinary legislation that was on the books. This wasn't to say it was a supreme law in each state on the same level as the Commonwealth Constitution for the federal level, but it was assumed to be a higher law, and it was assumed to have a higher status in the new federation that meant it could only be amended by express special legislation that was seeking to effect change to that respective state constitution, as opposed to the mere implied amendment or repeal, which can now take place by the state parliament merely passing an inconsistent or repugnant law, which is really what happens with every other piece of legislation. Where a new law is passed and it has a repugnant terms to an older law, it is assumed that the older law will have no effect where there is an inconsistency. Now, the jurists were essentially arguing in favour of this higher law on the basis that state constitutions required a sort of mandatory manner and form, a minimum procedure for them to be amended. Now, when compared with other legislation which can be amended or altered in effect by mere repugnancy to a newer law, this is really asking for the very bare minimum respect for what would have been state constitutions, that in order to amend them, because they're constitutions, they have this higher status, you do need to pass something express and specific to a state constitution. That was met with a long debate about this, and ultimately, as I've stated, the High Court has favoured the ordinary legislative approach. But first, let's discuss some of the thoughts that were going around in the early 20th century that led to this understanding. So this debate really kicked off in the High Court in the case of Cooper and Commissioner of Income Tax for the state of Queensland in the year 1907. In that case, a number of judges actually, in obiter dicta, found that states must pass special amendment laws to alter their constitutions. As I said, repugnancy alone they did not consider to be sufficient to amend state constitutions. Chief Justice Griffith, who really championed this idea that states had a higher status in their constitutional law, asserted this when he stated, and I quote, "In my opinion, therefore, the legislature could not disregard the provisions of the Constitution as existing for the time being, so as to be able to pass a law inconsistent with them, without first altering the Constitution itself." End quote. So Griffith really did support this notion of higher status for the state constitutions and requiring the minimum provision of manner and form that there be some special condition, being an express amendment being passed before the change to the state constitution could be effected. In this, Justice Barton actually agreed in equally clear and principled terms that amendments needed to be expressly made. And he actually said in his judgment, and I quote, "Legislation which could not be undertaken at all without the antecedent authority of the fundamental law cannot overstep the bounds set for it by that law and yet stand good." End quote. So what Justice Barton really said is, at the end of the day, you can't make a law that's just inconsistent with your existing constitution because it has that higher status. If you don't go and amend your constitution first, the law which you make afterwards, which is only made because that constitution grants you power, is just not going to be valid. It simply cannot stand on its own. First you have to have a valid constitution and a valid set of powers, and then you can make a law after that. The most important thing that both of these judges agreed on is that ultimately, whether or not a law was valid or invalid after the fact, ultimately the state constitutions had this higher status and required a special procedure, unlike ordinary legislation, to be amended. Justice Isaacs, whose constitutional ideas were actually often converse to those of Chief Justice Griffith, actually offered a full agreement in this case with the Chief Justice. But by 1917, the view of the court ultimately began to shift to the new accepted position that ordinary legislation, and by extension implied amendment and repeal, could effectively change state constitutions. Now the shift really took place and can be seen as taking place in the case of Taylor v. Attorney General of Queensland in the year 1917, which is in volume 23 of the Commonwealth Law Reports, starting at page 457. This was the first case where the ordinary passage of legislation approach to state constitutional amendment was actually accepted by the High Court. Under Section 2 of the Queensland Constitution Act 1867, a bill required approval of both houses of the Parliament to become a valid act. In 1908, however, an amendment was passed which provided an alternate procedure, namely that if a bill was passed twice by the Legislative Assembly and rejected twice by the Legislative Council, it would be put to a referendum of the people to decide whether or not it should then go to the state governor for royal assent, thereby ultimately bypassing the Legislative Council's approval as the upper house. No reference in the amendment law was made to address the requirements of Section 2 of the existing Constitution, however, which required that any law actually be approved by the Legislative Council. Ultimately, the court found that the 1908 Referendum Act was ultimately valid despite this omission of reference to Section 2. And this was based on Section 5 of the Colonial Laws Validity Act, which was still binding at that point, which granted the state governments a broad power to modify their own institutions as they really saw fit. The judgment was an effective endorsement of the implied repeal approach to state constitutions that we now obviously have in place, though it sat rather awkwardly with the earlier decision in Cooper that I just mentioned. In 1915, a further amendment to the Queensland Constitution sought to abolish the Legislative Council completely. When the upper house rejected this, as one would expect they would, the government proposed to invoke the referendum clause to actually resolve the issue, which triggered the Taylor case that I just mentioned. The High Court in this judgment also therefore found, by extension of the ordinary legislation approach to state constitutions, that it was possible also for states to go from bicameral legislatures to unicameral legislatures by abolishing a House of the Parliament. Conversely, they could, in theory, also add a house if they wished. And that's just me adding, I guess, a sort of theoretical note there for you. You can take a house off and potentially you could add one or two on if you wanted to. Justice Isaacs held this was consistent with Section 5 of the Colonial Laws Validity Act and stated at page 474, and I quote, "I read the words constitution of such legislature as including the change from a unicameral to a bicameral system or the reverse." Likewise, Justices Barton, Gavin Duffy and Rich agreed with this position. They each found that so long as the government remained representative in its fundamental character, it was possible to change the structure of government in such a manner as the Parliament saw fit. Justice Isaacs did, however, create a caveat in his judgment, that such a power to amend and alter the structure of the state government does not include the authority to eliminate the Crown in the states, and that this could not have been included in the ambit of such a power to modify the government as was granted to the states through the Colonial Laws Validity Act. That state constitutions are dealt with as ordinary legislation and subject to implied repeal through inconsistency with newer laws was also confirmed by the Privy Council in the case of McCawley and the King, 1920. In this case, the Queensland government in 1916 created a special court of industrial arbitration. The court's judges had a renewable 7-year term on the bench. Further provision was made also that a president of that special court, if later appointed to the Supreme Court of Queensland, would have all the rights and powers of a judge of that higher court, this ensuring that once elevated, the judge would be entitled to a life tenure on the Supreme Court. The argument was made, however, that the 7-year term which applied to judges of the Special Industrial Court also applied to their appointment on the Supreme Court, making such a judge thereafter limited only to a 7-year term on the Supreme Court as well. After Thomas McCawley was made the inaugural president of the new Industrial Court, he was just months later elevated to the Supreme Court bench as well, and with life tenure on that court. However, when he was presenting to take the judicial oath, members of the Queensland Bar objected. The argument was mounted that it was unconstitutional for the Legislature to impliedly amend the state constitution to allow appointments to the Supreme Court for a fixed 7-year term. The High Court on Appeal, reviving the higher law doctrine, actually agreed that such an implied change to the state constitution was invalid. Nonetheless, the High Court's decision was ultimately overruled on appeal to the Privy Council, which confirmed the plenary power of the Queensland Legislature to pass laws which in their terms and effect caused implied repeal or amendment to the provisions of the state constitution. So in this case, McCawley and the King, the Privy Council really does settle the issue for Australia. Lord Birkenhead, who gave the judgment for the Privy Council, found, and I quote, "It is of the greatest importance to notice that where the Constitution is uncontrolled, the consequences of its freedom admit of no qualification whatever. The doctrine is carried to every proper consequence with logical and inexorable precision. It was not the policy of the Imperial Legislature at any relevant period to shackle or control in the manner suggested the legislative powers of the nascent Australian legislatures." End quote. The Privy Council decision in McCawley found therefore that the state parliaments are what is called uncontrolled, and that their constitutions are just ordinary legislation. They don't have any higher status. This was a significant difference, obviously, between the Commonwealth Constitution, which is considered a supreme law within Australia, and the state constitutions, which are ultimately, as I've stated on numerous previous occasions, really just procedural, ordinary legislation. With this in mind, though, the court has determined that there is room for state parliaments, through their plenary power, to create what is called manner and form procedural requirements, which must be met before an amendment can be effectuated. This dictating the procedure rather than the substance of an amendment. So with that, let's move on to manner and form requirements. A manner and form requirement, broadly defined, is a restrictive procedure which is set by the Parliament of a state, and it must be followed in order to amend or repeal a legislative provision. As such, they impliedly restrict the legislative powers of the Parliament by requiring that certain laws on certain topics may only be enacted usually by a special or more difficult procedure. The justification for these provisions comes originally from the Colonial Laws Validity Act, but can now be found in the Australia Act 1986 of the Commonwealth jurisdiction. Relevantly, Section 6 of the Australia Act states in part, and I quote, "A law made after the commencement of this Act by the Parliament of a State, respecting the constitution, powers, or procedure of the Parliament of the State, shall be of no force or effect unless it is made in such a manner and form as may from time to time be required by a law made by that Parliament." End quote. The practical effect of this provision is that state parliaments may create special procedural preconditions for amendments which are to occur, which would affect their constitutions, or their powers, or potentially the parliamentary procedures. This could include, for example, setting a condition that an amendment only is effected by requiring a supermajority vote in either houses or both houses of the Parliament, or potentially also requiring the approval of voters at a special referendum. Now, after Queensland's Labor government abolished the Legislative Council, there became a fear within New South Wales that the same could be accomplished in that state. As such, the Premier of New South Wales in 1929 passed an amendment to the state constitution which required that under Section 7A, firstly, the Legislative Council could not be abolished without a referendum, and also that Section 7A, which was protecting the Legislative Council, also could not be amended without a referendum. This was what became called a double entrenchment. It is utilised to ensure that future parliaments do not skirt the manner and form provision requiring the referendum to abolish the Legislative Council by simply repealing Section 7A itself. It ensures the hurdle exists regardless of the course chosen by government. Whether or not the New South Wales government likes it is going to have to resolve the issue by referendum, whether it's to abolish the Legislative Council directly or to repeal 7A. People will have to get a say on it in that state. In 1930, the New South Wales Labor government sought to abolish the Legislative Council, as was predicted, and by claiming that their plenary power allowed them to walk over such entrenchment provisions of the New South Wales Constitution, they ultimately tried to pass laws to that effect. Now, members of the Legislative Council, as in Queensland, sought to defend their positions and sued to the Supreme Court seeking injunctions, which were actually granted by the Supreme Court of New South Wales, along with a declaration that none of the amendment laws affecting the Legislative Council status could be presented for royal assent without first going to a referendum, as was required through Section 7A. Now, the New South Wales government, being led by Premier Jack Lang, then decided it would appeal to the High Court to secure a resolution to the issue which had ultimately arisen since the Supreme Court gave an injunction. So it's at that point we get the case of Attorney General of New South Wales against Trethowan in the year 1931, which you can find at volume 44 of the Commonwealth Law Reports, starting at page 394. In that case, the High Court affirmed the New South Wales Supreme Court's decision by a majority of 3 against 2, with Chief Justice Gavin Duffy and Justice McTiernan dissenting. The majority in this case found that it did not turn upon the sovereign power of the state parliament, as had been the issue in previous cases. Rather, in this case, the majority found that it was within the power of such a legislature, as the states were, to determine its own process of lawmaking. This includes, from time to time, creating special requirements to be met before changes could be made. As Justice Rich stated, and I quote, "There is no reason why a parliament representing the people should be powerless to determine whether the constitutional salvation of the state is to be reached by cautious and well-considered steps, rather than by rash and ill-considered measures." End quote. In His Honour's opinion, the referendum requirement concerned only the manner and form of the legislation and didn't dictate any substance. Additionally, it didn't really conflict with the representative character of the state governments overall. As Justice Dixon held, and I quote, The power to make laws respecting its own procedure enables it to prescribe rules which have the force of law for its own conduct. Laws which relate to its own constitution and procedure must govern the legislature in the exercise of its powers, including the exercise of its power to repeal those very laws." End quote. The case therefore found that the manner and form provision was valid, and that the Lang government had to hold a successful referendum if it wished to abolish the Legislative Council. Ultimately, it was an unpopular idea to completely abolish the Legislative Council in New South Wales. However, in the year 1933, a successful referendum was held in that state to amend the powers and membership of the Legislative Council. Nonetheless, Justice Dixon in his judgment did go further, discussing the powers of state parliaments generally in adopting their own constitutions. His Honour stated, and I quote, "There is no logical reason why the authority conferred over its own powers should not include a capacity to diminish or restrain that very authority. But, in giving every representative legislature the power to make laws respecting its own powers, Section 5 of the Colonial Laws Validity Act provides not only that the power shall subsist, but also that it shall be deemed at all times to have subsisted." End quote. In this, it seems that Justice Dixon agreed in some measure with Chief Justice Griffith, that even were the state parliament to limit itself, ultimately they could not alter the fact that they had been endowed with plenary power originally, which would always exist at the foundation of the state's exercise of authority. His Honour found that the conferral of power through the Colonial Laws Validity Act did not include a capacity to diminish or restrain that fundamental authority, that even if the Parliament chose to exercise its powers in a restrained manner, that wouldn't change the ultimate endowment of power which they had originally received, that they were always to have plenary power, even if it merely subsisted under the surface. The High Court's decision in Trethowan was confirmed on appeal to the Privy Council. Ultimately, so long as the manner and form provision has been entrenched, the High Court found that such procedures will be deemed valid. However, this is limited only to provisions prescribing a procedure for amendment, as opposed to the substance of future laws. The difference became clear in the case of Southeastern Drainage Board of South Australia against the Savings Bank of South Australia in the year 1939, which you can find at Volume 62 of the Commonwealth Law Reports, starting at page 603. In that case, Section 6 of the Real Property Act 1886 in South Australia said that land covered by the Act will not be subject to any future laws unless those future laws use the words "notwithstanding the provision of the Real Property Act 1886. The Southeastern Drainage Amendment Act 1900 was a law affecting land subject to the RPA, but it did not use those words when it came into effect. The question in the case, therefore, was whether the Parliament could bind its successors as to the words used in future legislative amendments. Could it bind its successors to use certain words in the future when passing laws? The High Court determined that this wasn't a valid manner and form provision, as it prescribes the content of a future law, and not the manner and form in which they need to be passed. As such, a provision requiring such a declaratory clause will be impliedly repealed by any future law that is inconsistent with it. In essence, the provision can be ignored, as it is not a proper manner and form provision. Justice Evatt, in quite strong terms, disregarded the provision as it, quote, purports to lay down a rigid rule binding upon all future parliaments. It declares that, however clearly the intention of such a parliament may be expressed in an enactment, that intention shall not be given effect unless it contains the magic formula, end quote. The court therefore upheld in this case that the legislature cannot surrender or abdicate the substance of its future law-making power. This power must remain plenary. This has also been extended in some measure to find that the executive may not inhibit the power of the parliament to make laws either. One example of this is in the case of Westlakes Limited and South Australia, 1980, which you can find at volume 25 of the South Australian State Reports, page 389. In this case, the plaintiff company entered into an agreement with the South Australian government for the planning and development of a residential suburb. However, issues arose when a regulatory schedule of the government planning instrument was called into question. The provision required the express consent of the developer for the schedule to be revoked or varied. This meant that the executive's decision-making was to be subject to external non-government permission. The South Australian Parliament subsequently sought to pass a new law which would circumvent this permission requirement, at which time the developer sought an injunction in the State Supreme Court, arguing that the permission requirement was actually a valid manner and form condition which the Parliament had to meet before it could amend the law. The Supreme Court of South Australia in West Lakes ultimately found that the provision requiring the developer's consent was invalid on two main grounds. The first, and more fundamentally, was that it was an abdication of the Parliament's intrinsic nature as a governing body. His Honour Chief Justice King stated it was, in his opinion, quote, the clearest breach of the privileges of Parliament and of the members thereof, end quote, to have the government's decision-making reliant upon the permission of private entities. The second reason, consistent with the High Court's previously stated ruling in Southeastern Drainage Board, was that a provision requiring the written consent of a private company was not a valid manner and form requirement. His Honour Chief Justice King stated, quote, a provision requiring the consent to legislation of a certain kind of an entity not forming part of the legislative structure, including in that structure the people whom the members of the legislature represent, does not, to my mind, prescribe a manner or form of lawmaking, but rather amounts to a renunciation pro tanto, to a certain extent, of the lawmaking power, end quote. Ultimately, in this case, the Supreme Court of South Australia found that the provision was not a valid manner and form requirement, and therefore the Parliament was unconstrained to amend, repeal, or replace the provision as it saw fit. Manner and form provisions were once again examined by the High Court in the case of Attorney General of Western Australia and Marquet, 2003, which you can find at volume 217 of the Commonwealth Law Reports, starting at page 545. In this instance, the WA Electoral Distribution Act required that any amendment to the Act be passed by an absolute majority in both houses of the state parliament. In this case, the WA Parliament sought to repeal the 1947 Electoral Distribution Act rather than amend it. As this case occurred after the passage of the Australia Acts, to replace the Colonial Laws Validity Act, there was also an issue as to whether or not the same legal norms applied as previously under the British statute. The majority determined that as the Act concerned the election of Parliament, which is what gives the state its representative character, which is so fundamental as previous cases had determined, it is legally essential and is respecting the constitution, powers or procedure of the state legislature. On that basis, the manner and form provision in the Electoral Act was given a wide statutory meaning, as also including a barrier to the repeal of the law entirely. Chief Justice Gleeson and the majority determined concerning the move away from the Colonial Laws Validity Act that, quote, Section 6 of the Australia Act takes a different form. It provides directly for the requirement to observe manner and form. Nonetheless, the use of the expression constitution, powers or procedure in the Australia Acts is evidently intended to build on the provisions of the Colonial Laws Validity Act, end quote. As such, the majority concluded that the electoral law concerned the constitution of the state parliament and contained a valid manner and form provision. The provision which required an absolute majority to be amended was extended to any change, including, in this case, a repeal. As such, under the Australia Act, the state parliament was required to follow the entrenched procedure to make effective changes to the electoral distribution. Justice Kirby, who was in dissent, gave a more narrow statutory construction to the word amend, and held that it did not protect against entire repeals. It simply offered an extra hurdle to expressly or impliedly amending the existing Electoral Act. So now that we've gone over these cases, I'm just going to quickly summarise the position that's been stated. Firstly, the debate between whether or not a state constitution is a higher law or an ordinary law has been resolved that they are in fact ordinary laws. They can be amended by ordinary legislative processes, whether it be impliedly or expressly, even by creating a new law which is just repugnant to the existing constitution, which impliedly amends it. However, in some cases, the state parliament can, through express provision, prescribe a specific hurdle and a manner-informed provision for the special amendment of their state constitutions. This must be by a procedure. It cannot dictate the substance of a future law. So it's okay to set, for example, the requirement for a 2/3 majority of Parliament overall, or an absolute majority in both houses, or it's also possible to set a referendum requirement and a referendum procedure. However, it is not possible to set requirements for the substance of these laws, like, for example, what the laws must say, or what the amendments must include, or potentially, as happened in South Australia, requiring the permission of an external body to amend the constitutions or anything like that. So that's the position that we have in Australia, that state constitutions are really quite malleable, but ultimately there is a slight limit in that the government can from time to time create hurdles to amending their constitutions. So with all that stated, I'd like to broaden the context of this discussion to give you a little bit of contrast, and I'm going to do that by bringing in the United States of America as an example point. In the US, whose federalism Australia sought to replicate, we find a really good sort of comparison for how things are managed, not only on the federal level, but also, as we can see, on the state level. In the US, Nebraska is the only state which has a unicameral legislature, which is just one house of parliament, which is actually quite similar to Queensland. The other 49 states have bicameral state legislatures. The US Constitution provides much more, however, for the type of government and status of the states within their union. For example, in Article 4, Section 4, there exists the Guarantees Clause of the US Constitution, which states, and I quote, "The United States shall guarantee to every state in this union a republican form of government," end quote. The section places limits on the type of government that a state may have. This clause requires the United States government to prevent any component state, such as, for example, New York or Texas or California, from imposing rule by such government types as monarchy, dictatorship, aristocracy, permanent military rule, or even through majority vote. Instead, governing by electoral processes is constitutionally required. However, the Guarantees Clause in the US Constitution does not require any specific form of republican governmental structure. Thus, in cases such as Pacific States Telephone and Telegraph Co. v. Oregon in the year 1912, the Supreme Court refused to invalidate various forms of direct democracy permitted by state law, such as popular initiative and referendum, on the ground they might violate the Guarantees Clause. It should be noted, however, that the Supreme Court has also determined the limit is of a political rather than a judicial character, per the case of Luther and Borden, 1849. The court sweepingly declared later in the case of Colgrove and Green, 1946, that the guarantee of a republican form of government is not really justiciable in court. However, the Supreme Court always leaves the door open for challenges to be determined on a case-by-case basis. Much like in Australia, the courts in the US open themselves up from time to time to questions that border on being political, but ultimately choose to stick to matters of a purely judicial character most of the time. Nonetheless, the characterization given by the courts and the American founders seems to indicate that the provision is to prevent the adoption of undemocratic systems in the states. Authority for this, for example, is James Madison's observation in the Federalist No. 43, that, quote, "the states may choose to substitute other republican forms," end quote, which is his endorsement of the idea that the state governments don't necessarily have to reflect the structure of the federal government. State governments could be structured in a number of other forms so long as they keep what is a republican character. In this aspect, our system is analogous somewhat in that while states may amend their constitutions and their governments, both are ultimately restricted in that they must remain representative in character. I guess the only major difference between the two really is that while the US Constitution provides an express guarantee for this republican form of government, the Australian equivalent does not. Yet, one also must notice that the authorities we have just examined in Australia tend to show that the matter is much more justiciable and more confidently so in the Australian courts than it is in the United States courts. And that's obviously quite an important point to recognise as well. Another aspect which is relevant from the United States is the 10th Amendment to the Constitution, which provides, and I quote, "The powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively, or to the people," end quote. While in Australia state governments have plenary power, in the United States the state governments possess what is commonly referred to as police powers. This is a wide power of the states to regulate behaviour and enforce order within their jurisdiction for the betterment of the health, safety, morals, and general welfare of their inhabitants. States have the power to compel obedience to these laws through whatever measures they see fit, provided these measures do not infringe upon any of the rights protected by the United States Constitution or their own state constitutions, and are not unreasonably arbitrary or oppressive. This power and its limits were discussed in the case of Jacobson and Massachusetts. This case from 1905 can be found at the U.S. Supreme Court Reports, volume 197, starting at page 11, which, relevant to the present time, actually concerned whether or not states could enforce mandatory vaccination laws. The state governments of the US have controlled constitutions, to adopt the words of the Privy Council in McCawley, unlike their Australian equivalents, which makes them rather different, given that the Australian state governments have, as has already been determined in McCawley, uncontrolled constitutions. The reason the police power in the US is not deemed plenary is that it is subject to express limits found in both the federal and state constitutions, as I've stated. Especially since the passage of the 14th Amendment to the US Constitution, state governments no longer can claim any kind of plenary power to restrict the liberties of the people, subject only to their own constitutions in that state. In addition to this fact, the judiciary has also taken a very active role in ensuring that the police power and associated state powers are exercised appropriately, being tested as to whether or not they are indeed for the betterment of the citizenry. This can be seen particularly in the influential Justice John Marshall Harlan's judgment for the majority in Jacobson, wherein he quoted the judgment of Justice Field in the United States v. Kirby, found at volume 74 of the United States Report, starting at page 482. This judgment occurred in the year 1868, where Justice Field stated, quote, "General terms should be so limited in their application as to not lead to injustice, oppression, or absurd consequence. It will always, therefore, be presumed that the Legislature intended exceptions to its language which would avoid results of that character. The reason of the law in such cases should prevail over its letter." End quote. This can be contrasted with the Australian courts, who have determined that peace, welfare and good government, as I stated in the previous episode, are words conferring only a general plenary power, with no inherent limits, regardless of whether they indeed attain any of those outcomes. So having set out very briefly the nature of state governmental power in the US, there's also the question of how US state constitutions are amended. As their governments are controlled in the US by their respective constitutions, there is a strong focus upon state constitutional amendment and procedures which we in Australia usually never hear about at all. In 19 states of the US, the Constitution has been amended over 100 times since their establishment. Regular amendments are usually required as state constitutions are much longer and more detailed in their terms. Normally they are also much easier to amend than the federal constitution in that country. While the procedure for initiating the process differs in each state, so too does the difficulty of a successful amendment. For example, in California, the process may be initiated by the legislature, by a constitutional convention, or alternatively by a voter initiative. A proposed amendment by voters must be approved through a referendum. With the legislative method, a proposed amendment must be approved by an absolute supermajority of 2/3 of the membership of each house. The Californian Supreme Court ruled in the case of Livermore and Waite 1894 that the power to change the state constitution cannot be delegated to any individual, as the sovereign power to do so must ultimately rest with the people or their representatives. As such, the procedure must always be reflective of the representative character of a republican form of government. Another example is that in the state of New York there are two methods of constitutional amendment. Either a proposal must be published for 3 months, then approved by an absolute majority of each legislative house, at which point the amendment must then be approved again in a succeeding term of the legislature by both houses, with an election intervening that period. A second manner and form is that a constitutional convention be held. After either of these methods is accomplished, a referendum must be held, at which point a majority of state voters agree with the change to the state constitution. In Texas, the only method for proposing an amendment to the state constitution is through the legislature, either in regular or special session. The governor may call a special session and specify the agenda for that session, being the amendment of the Constitution. At which point, a proposed amendment must be approved by an absolute supermajority of 2/3 of representatives from each house of the legislature. It is only then submitted to voters in an election specified by the legislature to be considered. To become part of the Constitution, proposed amendments in Texas must ultimately be approved by a majority of voters in a referendum scenario. In Australia, there's a lot of reluctance to have referendums because of the wide impact they have and the cost. As such, there have been relatively few amendments in Australia to our constitution and relatively few state constitutional referendums as well. This is in stark contrast to the Texas Constitution, which has been amended 498 times since it was adopted in 1876, and it actually contains 86,936 words. It is, however, still only the second longest and most amended constitution in the US. The Constitution of Alabama actually takes first prize, having been amended 909 times since it was adopted in 1901, and it contains over 350,000 words in its true length. If you can recall from episode 1, our foundational episode, I actually gave you a little bit of a fun fact, that the longest national constitution on earth is the Indian Constitution, which, when translated into English, has something like 150,000 words in it. As such, if Alabama actually declared independence for a second time, it would actually take the position from India, dwarfing its competitor by almost 150,000 words. So if you ever feel overwhelmed studying constitutional law in Australia, just keep this in mind for some context. As an American law student in Alabama, you'd have to understand both the federal and state constitutional law, which are extremely complicated and long, as I've just set out. So if you're listening to this and you're struggling, just count your blessings in this very, very small regard. So the question is outstanding. Why is all of this actually important to you? Why is the last 50 minutes of this episode really so essential for you to understand, and why especially is the American information really great contextually for you to know? Today's episode really focused on wrapping up the basics of state constitutional law, and our focus on state constitutional amendment is relevant as it defines through its case law two very important aspects about our state governments. The first is the ordinary legislative status of their constitutions. The second is what constitutes a valid manner and form for amendment, specifically prescribing procedure, not the substance. This actually says quite a lot about the nature of our states, which are, after all, integral components of our federal system of government. That's actually why this is so important to you in terms of the Australian content. But it's also for this very reason that I followed from the explanation of Australian law with a point of contrast briefly to the United States, as our federalism through federation and that process is taken originally from their model, and they are arguably the nation which exemplifies best the principle in application. Understanding this comparative law actually gives you a more in-depth understanding of and appreciation for the Australian constitutional law which you are at the moment studying. So what can you expect on our next episode? Well, on our next episode we will start to set out the nature of Commonwealth legislative power, and we'll begin a series of episodes on some important powers the federal government possesses in Australia. We'll start slow with an overview and discussion of the Commonwealth Legislature in the next episode, and then over the succeeding episodes which follow, we will dive into each power in more detail. So, I hope you enjoyed this installment of the Surviving Constitutional Law podcast, and that you will join me for our next episode. Until then, however, I hope you stay well, and always remember to keep reading.